Wildflower versus St. Johns River Water Management District.
Good morning, Your Honors. My name is Frank Malika, attorney with Malika Law Firm, Merritt Island. With me is co-counsel Benjamin Saxon of Saxon Choctaw in Melbourne. We represent the plaintiff, Wildflower, here this morning.
How much time would you like for rebuttal?
I'd like 10 and 10, Judge, if I may.
All right, when the yellow light goes on, you'll be into the rebuttal time.
Thank you. This case is about 3 papers. They are the amended complaint, the motion to dismiss and strike filed by the defendant, and the order granting the motion to dismiss by the trial court. We're not entirely sure of what that motion to dismiss was, but it appears to be a motion to strike as a sham. We say that because the motion was verified in part. The trial court granted the motion and in the order stated that it was a motion to strike as a sham under 1.150. And the motion had attached to it an affidavit, which is something that can be done on a motion to strike as a sham. But we're approaching this appeal on the basis of it's either a motion to strike as a sham or it's a motion to dismiss. And the law is reasonably clear on either interpretation of the motion. On a motion to strike as a sham, and I might mention to the court what this is not is a motion for summary judgment. That's not what this motion is.
Counsel, it's your position that if this had been presented, the res judicata arguments, especially in a summary judgment argument, the court could have entertained it, correct?
Oh, yes, Judge.
So you're saying essentially, without getting to the merits of whether it was or wasn't res judicata, you're saying it's a procedural mistake to proceed by motion to dismiss and motion to strike rather than summary judgment, correct? Absolutely,
Your Honor. Okay. As I might describe it, the train has to be on the track before we could go down the line. Now,
and as I further understand, you and your wife, as operating the business, got rulings from appellee and DAX with regard to your use of the property. You then transferred the property to Wildflower LLC, which y'all are the members of, correct?
Yes, Judge. There are others involved in the company, but let me explain to the court.
Yes.
That all occurred before the issues we're raising in this complaint happened. And they do not necessarily involve that previous situation, but we pled it to give a background as to how this unfortunate situation arose. What we have is a decision, a binding determination is called by statute, and the Department of Agriculture, who is more or less the arbiter, I wouldn't call him an arbiter, made a decision, and the previous owners and the defendant is bound by it. The trouble is, trouble, I believe, arose because 4 months after they made that decision, and after that decision became final by its very terms, the defendant, unfortunately, engaged in ex parte activities with someone in the Department of Agriculture, and 4 months later, lo and behold, we have another ruling.
It's because there was an error in describing where certain activities were taking place?
No, Judge, because there was a scrivener's error, but that was not the problem. The second ruling went beyond the scrivener's error, which we...
In what way did it go beyond correcting the scrivener's error?
What it did, Your Honor, is attach a map to describe the area that it said they were exempting, but this map varies from the written description that was in the first ruling, our first determination, and also in the second determination. So the reason Wildflower is bringing this action is because we want the court to determine where is the exemption based upon the Department of Agriculture's ruling. And that is one of the issues. Now, instead, at this point, Judge, there is no factual dispute. The defendant has not disputed all of the facts that we've alleged in the complaint. They filed no answer in this case. And they brought a motion, the motion that we're dealing with here, which appears to be a motion to strike as a sham. However, they allege nothing untruthful. They did not say that anything was untruthful in the complaint. They did not say there was anything false in factual falsities in the complaint. What they said is that we're entitled to dismissal because we have the defense, which is an affirmative defense, of res judicata, and the plaintiff should not prevail. Well, it's very clear from decisions by this court that that's not appropriate. In fact, there's a case that I would suggest is almost entirely on all fours, and that is the Upton case, Upland. But this court has said to Judge John Antoon, a pleading is considered a sham when it is inherently false based upon plain or conceded facts, clearly known to be false at the time the pleading was made. 2 years later, and that case was the Destin construction case. 2 years later, Judge Antoon spoke again in the Decker case. The sanctions provided by Rule 1.150, including the entry of a summary judgment, are reserved in order to address pleadings containing false allegations of fact. Now, an affirmative defense, whether they have it or not, is not something pointing to a falsehood. It's something that points to a defense which may or may not be raised by a party in an action. There are a lot of affirmative defenses that may not be raised, such as statute of limitations and various other ones. It's not a sham pleading. And I would submit that the plaintiff is prepared to proceed with this case, showing that their affirmative defense is not accurate at all. But that's not the issue here this morning, I don't believe, Your Honor. The issue is, was the ruling by the trial court appropriate based on the rules of procedure? Judge Antoon continued, our court has explained that a pleading is considered a sham only when it is inherently false, clearly known to be false at the time the pleading was made. In deciding whether to strike a pleading as a sham, the trial court must resolve all doubts in favor of the pleading, and that is the law. 10 years later, Judge Torpy, on a similar issue, stated this in Nally v. Rothstein. A sham pleading that is one that is undoubtedly false and known to be so to the party pleading it. That is the law. In Upland Development versus Bridge, the defendant filed a verified motion to strike the complaint as a sham. Judge Thompson for this court said, Upland correctly asserted on appeal that the trial court utilized the wrong standard to reach its decision because it did not make a determination about the truth or falsity of the complaint's allegations and reversed the trial court. The case went on to say that affirmative defenses require proof and pleading so that the plaintiff can reply and have an opportunity to show the inaccuracy of the defenses. Res judicata is affirmative defense, undoubtedly, and the rules of procedure require that affirmative defenses be pled if you're going to raise one.
If it appears on the face of the complaint, though, or in this case, the amended complaint, the defendant then could assert res judicata if all the elements were asserted there, couldn't they?
I'm sorry, Judge, I didn't follow the thrust of your...
Even though it may be an affirmative defense, if the complaint itself set forth all the elements of res judicata, in other words, the prior action involving the same parties, the identity of issues, all the rest of that, then the defendant would have been, or the appellee would have been free to raise the defense at that point, wouldn't it?
Yes, if they were raised, but they're not raised. The allegations pertain to a different action by the defendant and the previous owners, and that occurred before the issues which were raised in this case, and the issues in this case have nothing to do with the previous action. For instance, there's an issue as to whether or not there is a closed agricultural system on the property. The previous administrative process was in 2009. This complaint alleges, if it's read closely, that the current system was constructed in 2011. So the court could not, there was no nexus between the two in that respect. The affirmative defenses also, an affirmative defense can be raised if it appears on the face of a prior pleading, but the motion to dismiss, raising that defense, must be one that's within the Rule 1.140, because Rule 1.140 states that you can only raise those affirmative defenses if it's on a motion of the a motion brought under 1.140. That is one of the 7 defenses which this is not. This motions to dismiss which this is not. So it didn't have the right to rely on a previous pleading, even if it did deal with res judicata, which it does not. And the actual complaint shows that it is not res judicata, and but different issues that arose afterwards, so it cannot be res judicata, and the issues were never decided by a court of competent jurisdiction. The previous owners never had an opportunity to raise those issues, as pointed out in the brief, because they were not discovered until after the previous appeal by the previous owner was taken. So I'd like to reserve.
You have about 6.5 minutes left for...
Okay, thank you, Judge.
May it please the court, my name is Gail Hankinson, representing the St. Johns River Water Management District.
Was this case dismissed as a sham? Was that the basis of the...
No, Your Honor, I do not believe that it was.
Did the trial court say it was a sham in its order?
No, it did not, Your Honor. I believe that in a declaratory judgment action, the trial court goes through a two-step process in order to invoke jurisdiction. And first is to look to the sufficiency of the pleadings and see whether or not a declaratory action has been pled. Is someone in doubt as to a right that they have, that it's their right, that they have a entitlement to have that doubt resolved, and that there is a real need, an apparent need for such a declaration. If a court finds that the pleading is legally insufficient, it might dismiss it as for failure to state a cause of action. But if it finds that it meets the pleading meets the minimum requirements for stating a cause of action, in declaratory actions, as the courts have repeatedly stated since 1950 forward, the jurisdiction of a trial court in a declaratory action is discretionary with the trial court and is not a matter of entitlement of the litigant. And how that comes into play is that, separate from the issue of whether a complaint has been properly pled, the court can look to the circumstances of the case to determine whether it's going to exercise its declaratory jurisdiction. And when a court makes a decision in that discretionary realm of its discretion to exercise or not exercise for a particular reason, that is the order of the trial court that comes to this court clothed with that it was a discretionary order that's entitled to great deference and will not be overturned absent a showing of an abuse of discretion.
What was the basis of your motion that led to the court's order?
We did file a motion to dismiss and strike under sham pleadings. It was the district's opinion that the pleadings were a sham and that Wildflower was not in doubt as to any right that it was asserting in any of these claims. We also, as Justice Edwards was pointing out, under Rule 1.110D, it does state that if the previous pleading on its face shows the existence of a defense of res judicata, that it can also be raised by a motion to dismiss. And we feel that the attachment of the binding determination as an exhibit to the amended complaint, the attachment of portions of the final order that this court affirmed on appeal, that those were showing that there were final determinations and that res judicata that defense could apply.
Was there evidence or allegations on the face of the complaint for the unity or identity of parties, though?
Yes, Your Honor. In the face of the complaint, the Wildflower indicated that it was now the new owner of the property and that it had all the rights and choses in action of the grantors. And through the attachments to the pleading, the grantors were identified, the previous owners, as Frank and Linda Malika.
Did your motion to dismiss raise this discretionary jurisdictional argument that you're now saying is the basis on which the trial court's order of dismissal was entered?
I believe that we certainly raised that at the hearing on the motion to dismiss, that the court should not exercise its discretion to entertain the case. But independent of whether we made that argument, the court would have its own authority to make that discretionary decision. And I believe clearly the order, if we look at the order that was entered here, and I believe that that is the only issue that is before the court today, is whether the court committed reversible error in entering its order dismissing the claim below. And that order, of course, comes to this court closed with a presumption of correctness. I assert that it was made in this discretionary realm of the trial court and is also entitled to great deference and should not be set aside but for an abuse of discretion.
On the sham issue, you indicated your belief as to the sham was the allegation that the plaintiff was in doubt about its rights?
That's correct.
Is that the only allegation that you say is a sham?
But it was the entire allegation, that this Wildflower LLC, as the new owner, it was just deeded the property in December of 2013, when this court issued its PCA opinion affirming the final order that had been appealed by the Malikas. Now this Wildflower LLC says, you know, I need a declaratory instruction or a declaratory statement from a circuit judge interpreting this final order. Mr. Malika actually filed a petition for rehearing en banc on January 14th, 2014, making this court's PCA non-final at that time, and then 2 weeks later filed the original complaint in Brevard County, January 27th, on behalf of Wildflower, asking for a declaratory judgment with count one, asking them to interpret the final order that was then pending here at the 50CA.
Was there an issue about a closed system that post-dated the decision from the first case?
In the original case, the Malikas asserted that they had that there are two exemptions that are involved here. One is the agricultural exemption, and one is the closed system exemption. It is not particularly an agricultural exemption. In the original administrative hearing, the Malikas asserted that they were entitled to both of those exemptions. The original administrative hearing officer who heard the case concluded that they were entitled to neither, but since during that process the legislature enacted a law saying that the Water Management District should not be the agency determining whether an agricultural exemption exists, and gave that authority to the Department of Agriculture and Consumer Services, Mr. Malika availed himself of that opportunity to ask for the Department of Agriculture and Consumer Services to make the determination on the agricultural exemption. The Department of Agriculture reviewed it and came back stating that a portion of the work that was done did fall within normal customary agricultural activities, but another portion of the work did not. The corrected order that Mr. Malika complained about, and we're sort of getting off on a weeds here, but the DACs specifically stated in their corrected order that they were correcting a Scrivener's error and that there was no substantive change in the determination between the two orders, but that they did attach a map so that it would be illustrative of where the unauthorized wetland impacts had occurred.
So I'm a little confused. You initially said that they requested administrative hearings on both the closed system exemption and the remember now the other issue, agricultural exemption?
Yes.
And now you're saying, I guess, I thought from your filings you said that your position was they never requested the hearing on the closed system exemption. Is that correct?
There's a difference between the hearing, or what I'm saying is that he raised before the administrative law judge that there was a closed system on the property. The Malikas never availed themselves of the Administrative Procedures Act opportunity in 120.565 to obtain a declaratory statement from the agency about the application of an exemption to the facts at hand. That opportunity to ask for a declaratory statement from the agency about the existence of that exemption still exists today for Wildflower or the Malikas to make that request. They have never availed themselves of that administrative procedure to address that issue.
There had been a misstatement in an earlier version of the complaint that they had availed themselves of that.
Correct, Your Honor.
That was not the fact.
Correct, Your Honor.
That would have been a proper subject for a motion to strike as a sham pleading, correct?
Right, but I think it's important to look at what the judge did rule on in this case as opposed to what might have been a consideration.
We didn't have that false statement in the current version. That statement was withdrawn or corrected, however you want.
It was withdrawn.
Well, doesn't that procedurally correct the issue then, as far as that misrepresentation?
As far as that particular misrepresentation, yes, that obvious inaccuracy was removed, but the issue of whether or not it was a sham for Wildflower LLC to be in doubt as to these proceedings that had been litigated for over 5 years, that was the primary thrust of the district's position. And if the appellant in this case had provided the court with a transcript of the proceedings, you would have had the benefit of that argument and the court's consideration of those issues. But that was not provided. I just wanted to go back to the issue that is before this court today, and that is whether the court could properly exercise this discretionary authority to decline to entertain jurisdiction in this case. And I'd like to...
Does the trial court have discretion whether to entertain a request for injunctive relief?
The injunctive relief is dependent upon the declaratory statements here. So if the injunction was simply asking for a temporary restraining order to allow the court to address counts 1, 2, and 3. When the court dismissed counts 1, 2, and 3, then clearly count 4 would fall as an ancillary complaint to those first.
To get the court to the position below not to exercise its discretionary jurisdiction, you had to get into the res judicata issues, didn't you?
No, Your Honor, not at all. And
Did she discuss that?
No, she does not. If you look to the conclusions of law that are stated, I believe it's very clear that she is exercising her discretion to decline to take jurisdiction in this case. If I could, I would like to discuss with the court 4 cases where a trial court electing to not entertain declaratory judgment jurisdiction was upheld by the appellate courts. First, there are 2 cases that I'm going to refer to that the court declined because the issues being raised in the declaratory judgment were the subject of an earlier filed suit. I discussed in the answer brief at length the case of Department of Environmental Protection versus Garcia. And in that case, the Department of Environmental Protection brought a declaratory judgment action, and the trial court recognized that the issues that were being raised in the declaratory judgment action had already been filed and raised in other proceedings, actually a negligence claim that was between the same parties. The lower court ruled that even with a well-pled complaint for declaratory relief, so the department had established in their complaint all of the elements needed for a declaratory relief claim, even in a well-pled complaint where the circuit court could have exercised its declaratory jurisdiction, the appellate court stated that it would have been an abuse of discretion for the trial court to have entertained the declaratory action on issues that had been raised and ruled on in the earlier filed and still pending case. In this court, this case of Berrios versus Duke Spine, and I believe Judge Edwards, you may have been on that panel, or perhaps it was Judge Palmer. But in Berrios, which is a 2011 case, this court recognized that while the existence of another available remedy does not preclude a judgment for declaratory relief, a viable declaratory claim must be asserted and exceptional circumstances must be shown for the prosecution of such a claim where there is a pending suit at the time the action is initiated and the issues raised in the action can be resolved in the pending suit.
Your motion to dismiss raised 3 arguments. Res judicata precludes consideration of the issues, sham pleading, and lack of standing, correct?
Yes, and that standing was in the alternative as it was argued before the lower court.
And the trial court entered an order which granted your motion to dismiss. So how can you say that's an order where the trial judge is exercising its independent jurisdiction to decide whether or not to consider a declaratory judgment action? If that were the case, it wouldn't be granting your motion, because that's not the argument that was raised in your motion, correct?
Well, Your Honor, the trial court may have been inartful in the phrasing of it, but it is clear from the conclusions of law that the court went through, where it stated in each of the conclusions of law, in conclusion of law A, it identified that the defendant in this case was an agency of the state, then B was that it was a declaratory action, and in C, the trial court specifically laid out all of the claims that were being raised by the plaintiff in that case, and it made clear that there were no claims being raised by the plaintiff that were in the primary jurisdiction of a circuit court, such as the constitutional attack on a statute or ordinance, which would be inappropriate to be deferred to an administrative proceeding. She laid out all of the claims that were being requested by the plaintiff, and they were all in the nature of interpreting or applying or reconsidering regulatory and administrative matters. The first count was to interpret the final agency order and the Department of Agriculture and Consumer Services binding determinations. The second was an issue of applying the facts of his system and whether it met the statutory exemption. All of the claims were dealing, the third was with interpreting the corrective actions that were in the final agency order that had been affirmed by this court. So it laid out that these were not areas where a circuit court had primary jurisdiction and that they were specialized areas of administrative law. She then went on, and in finding E of the conclusions of law, she specifically quoted from this court's opinion in St. Johns River Water Management District versus Malika, where this court directed that the legislature had given the authority to water management districts to regulate wetlands, and that the proper exercise of that authority was for the administrative processes for review. After she quoted extensively from this court's opinion, her next conclusion of law was that the claims being made by plaintiff here are more properly addressed by the administrative process, and accordingly, she dismissed the case.
Accordingly, she granted the motion to dismiss that the defendant had filed. That's different, isn't it?
Well, perhaps inartfully, but I think that it's clear from her conclusions of law that she was not making findings of fact that the sham, that the pleadings were false, or that there was privity. There were no conclusions of law establishing that type of a granting of the motion that we were making.
Notice to the parties that it was going to be considering whether or not to exercise its jurisdiction and discretion to not hear the case, as opposed to simply the hearing came on the motion to dismiss, filed and noticed by your client.
I don't believe that it did, but I don't believe it had any obligation to do so, and I think the other cases that appellate courts have affirmed show that is frequently what happens, that it's on a motion to dismiss for failure to state a cause of action or such, and the court says, I find that I have jurisdiction, the action is well pled, but I elect not to exercise my jurisdiction because I find another forum is more appropriate. I would address the court's attention to two cases that found just that. One, as cited in my brief, the Jacksonville Roofing and Sheet Metal case versus Local Union 435. There, the Employers Association brought an action for declaratory judgment to construe a collective bargaining agreement. The trial court declined to exercise jurisdiction, deferring to the local joint adjustment board to make its determination on the dispute. The appellate court affirmed, stating, "In our opinion, not only has no abuse of discretion been demonstrated in this appeal, but we think that the chancellor, in his order, exercised a very sound judicial discretion in ruling as it did."
Thank you, counsel. Your time has expired.
If I could just give one case, which is Hartford versus Cleary at 737, 567.
Time's expired, counsel.
Thank you.
To please the court, I point to the motion to dismiss, which says, the order granting says, defendant's motion to dismiss and strike filed on June 25th, 2014, pursuant to Rule 1.150, Rules of Procedure. That's the sham pleading rule. And then she grants the motion, so there's no question that she granted it on that. As far as, excuse me for talking fast, but I want to try to get it all in. As far as affirmative defenses appearing on the face of the prior pleading, I submit to the court a careful reading of this complaint will show that they do not. The contentions in this motion or in your argument has to do with a different set of facts.
What of Appellee's argument, though, that the trial court has discretion to entertain or not a declaratory judgment case?
Well, Judge, I think that's appropriate motion. I mean, it may be appropriate theory if it was a motion for summary judgment, and I think that they could have came in and argued that. But they were arguing here a false pleading, and we came in to respond to that issue of a false pleading, which it was not. And on a motion to dismiss, the court is supposed to, by law, consider everything within the four corners of the complaint that is truthfully, that is pled as true, and accept them and give all reasonable inferences therefrom. So we were relying on the law, and the issue she's raising really goes to whether or not the complaint stated a cause of action. They did not make that motion. Now, the rules of procedure state that as far as raising affirmative defenses, you may only do that if if you're making a motion to dismiss based on Rule 1.140B, and those are listed, and they didn't file one of those motions. For instance, lack of jurisdiction over the person. If they had filed that motion and they could point to something in the complaint then they could raise it. But everything they raised is not within that rule. Now, the issues are what the issues say in the amended complaint. They're not what the defendant argues. The court has to accept those as issues. And I think there are records that have been filed will show that in that previous appeal, Your Honors, because of the sequence of the discovery of the activities of these two attorneys for the defendant, and I regret having to say that, so the plaintiff attached some of the documents which substantiate it's not some sort of a wild accusation, that because on that, and because of the way that these activities were discovered, they couldn't be raised in that appeal that is before this court, and the documents showed the plaintiffs attempted to do that by filing a motion to supplement the record to bring in those documents and for relinquishment of jurisdiction so they could pursue the action against the St. John's for that, but the court denied it. we accept the denial, we don't know the reason it was just denied. So there was no opportunity to ever bring this up, and res judicata requires a determination by a court of competent jurisdiction on the issues. So there is no res judicata here for a number of reasons. And the lack of standing pled by the defendant, if the court, I know the court has looked at it carefully, it's not pled in the alternative. They make the assertion that Wildflower was never a party to the previous proceedings, either administratively or otherwise. On the other hand, they now argue that Wildflower is not able to proceed in their motion based on res judicata. So it was either a party or it was not, and so they pled both ways, and I guess in an effort to find some basis to sustain their motion. But a motion for sham has to plead something that's untruthful, and that's what they pled. A motion to dismiss as a sham, or strike as a sham. And there's nothing untruthful in that. And a motion to dismiss has to rely on the allegations. They never denied the allegations. They never denied any of the allegations. They refused to file a motion, or file a pleading responding. The plaintiff, in an effort to get them to do that, filed a motion for default to hope that they would file some sort of pleading, and they refused to deny the allegations. And one can only assume that the allegations were considered by them as true, so they're attempting to use a defense that they're not allowed to do under the rules of procedure. And I would suggest to the court that that's what this case is about, not some sort of discretionary. When a motion to strike as a sham is filed, it would vitiate the rule and the rulings of this court if they can just go on off and say, well, they had discretion to do it anyway. They didn't have to go by the rules of a motion to strike as a sham or a motion to dismiss. They could do it anyway just based on discretion. And I don't think that should be the law, and I don't think it is the law. And I see my time is about up. And I'm not sure if the court has concerns, but I would be very pleased to answer any questions if it does.
Thank you, Counsel. Your time's expired.
Thank you.
We'll have a panel change now for the next case, which is Palazzo versus Funk.